Welcome, Prime Minister. Thank you for your time. This is the first edition of One on One. I know we have lots to talk about today, so welcome.
Thank you.
Today, we want to know recently, the CCJ made a ruling concerning the GCOM chair, and in that ruling, it involved the government, the president, and the opposition leader meeting. Is there any update from your end concerning the joint talks?
Those talks are ongoing. The president and the leader of the opposition, they have appointed representatives who are meeting outside of the so-called summit. And they are what the CCJ had guided to be a process involving hammering out names that have been submitted to both sides to ensure that at the end of the day there would be 6 names that would probably be considered to be not unacceptable by the president, and those names have to be submitted by the leader of the opposition to the president. So the process, as we knew it, was for the leader of the opposition to submit a list consisting of 6 names. On this occasion, since this is a new process, the leader of the opposition submitted a name of 11. And the leader of the opposition has said that the president could, in fact, submit names to him. So there are 8 names in addition, so there are 19 names at the last time on the table. And let me say this, that there have been some misconceptions as to what the CCJ has recommended. The CCJ has recommended that you have to blend principle with practicality. In other words, to be able to move the process into a more consensual basis so that both sides can talk about the names and they can try to reach consensus. So the CCJ gave an interpretation of the Constitution that the president should have a role in identifying the names, and that the president should be able to participate in this process of hammering out the names. Imagine they will have some discussions, some trading here and there, and so on, so that the end result should be a list that would be deemed to be acceptable by the president. So I think that process is going on very well. And I would say that so far that both sides seem to be acting in good faith.
I know that the discussion has been from the beginning that the government would like to see credible elections in a timely manner. Is there anything else you wish to add?
The president has addressed the nation on more than one occasion. And on all these occasions, one thing was common, that following the no confidence motion, the president said he wants early elections. But those elections must be credible as well. They have to be based on the assessment by the Elections Commission as to where the process is as regards preparing the voters list. There is no voters list at the moment. The last voters list expired on the 30th of April this year. So there would be a requirement, as GCOM itself has said, for a house-to-house campaign, a house-to-house process to register those voters who have not been on the list, and secondly, to check to see if voters might have emigrated or they might have changed places of residence. So this should be an interesting but very important process to clean the voters lists. There are opinions based on credible facts that the voters list, as we have and had been used in previous elections, would have the names of over 200,000 persons who shouldn't be there, phantom persons on the list. So while we are saying that we would like to have early elections, we are also saying that those elections must be credible. They must be free, fair, and appear to be fair, so that no one can come forward and make allegations as to the transparency process, as to the process of credibility of our elections. So we are still, yes, the president has said it even yesterday, that we are committed to early elections, but we are committed to a process where the president would make a proclamation to direct the elections to a date when it could be held, based on the advice from the Guyana Elections Commission. And as you know, that cannot happen unless you have a chairman of the Elections Commission appointed.
All right, thank you for the clarity on this. Another thing that requires clarity is recently there's been a movement for the amendment in the Narcotics Act. Persons have been buzzing on social media with their own comments, obviously. Is there any clarity you wish to provide with regard to the recent statement by government?
On April 30th, Cabinet met during one of the retreats in Linden, Watuka House. And during that meeting earlier in the year, a decision was taken for the amendment of the law dealing with cannabis. And the content of that decision was that government would seek an amendment that would allow the possession of 30 or below grams of marijuana to be exempt from the provision of law whereby you could go to jail. In other words, if you are in possession of 30 grams of marijuana, it's not legal. It's still against the law, except if you're caught, you would not, and you're tried, you would not be sentenced to mandatory imprisonment for a period up to 3 years for a small quantity of marijuana. The court may fine you. The court may prescribe community work. We are soon to have a court that will be called the Drugs Treatment Court, where you have alternative remedies for those who may be caught with small amounts of marijuana. So that proposed amendment has been submitted to the National Assembly, and we are hoping that it will be placed on the notice paper so that it could be approved, debated and approved at the next possible sitting of the National Assembly. But I'm glad you asked the question. It's a good question as to where it is, because look, when we got into the government in 2016, very soon after, I led a delegation representing the executive, representing the presidency, that met with the chancellor then, Carl Singh, and some others, the chief justice and the chief magistrate, and we discussed the issue of the overcrowding in our prisons. We found that there had been a prison riot, and it was based on the fact that prisoners felt that that a prison that was made for 600 persons had already had well in the vicinity of 3,000. And they raised concerns that were legitimate concerns. And so it flowed from the fact that the prison had been overcrowded. And so many of those who formed the overcrowded section of the population, prison population, were in there for small quantities of marijuana. And we took an approach then that they should expedite the hearing. Those who were on remand and weren't able to post bail, to find some creative way of dealing with that. So the chancellor then agreed that they would set up a drug treatment, set up rehabilitation sentences. They also decided that we'll appoint night courts and temporary magistrates to deal with the issue. Magistrates found themselves going to the prisons. Rather than the prisoners coming to them in court, they were going to the prisoners and setting bail and so on to ease the overcrowding. So at the moment, the issue of young people in jail is a social problem. It's a national problem. And young people do not belong to jails. Young people's future cannot be imprisoned. And so I believe that this is a very creative and purposive move by the government to ensure that we do not condemn our young people to a life in prison, a life of solitary existence, but that they should realize that if they commit a wrong, that there are other methods of remedying that wrong. And that's why there's alternative resolution of some of these offenses.
And when you visited a community meeting recently, you made a powerful statement that incarceration is not for the youth. And also at that meeting, I think there was discussions, or the public was aware at that time that there will be collaboration between the Ministry of Social Protection and the Ministry of Public Health.
Yes, and so it's a collaborative effort because we see this as a social problem, as a sociological problem. And more than that, some groups from the Rastafarian community, they came forward and they said that, look, we agree with the proposal to not to apply mandatory custodial sentences for 30 grams and less, that they are not at the moment asking for the legalization of marijuana. They're asking for the relaxation in the sentencing policy. And that's what we did. Magistrates have been complaining that their hands are tied, that they know that there's someone before them with 6 grams of marijuana or a smoking utensil, for example. And they didn't think that the person should go to jail for a year or 2 years or 3 years for a small amount. But they don't have a discretion under the law. And therefore, we now untie the hands of the magistrates who hear these cases. We also are hoping that the police force would take judicial notice of this move by the executive, and that they are going to relax the stringent application of their function to arrest persons with small quantities of marijuana. So in the approach towards liberalizing the law, already you may have kicking in a kind of process that would not see young people being hounded and charged and placed with the court for a very small amount of marijuana. There are some other things in the law that would have to be observed and applied, like question of smoking in public or sniffing or so on in a public place. So the law, when amended, will address those issues.
Thanks again for clarifying that. And recently, as of this week, the President reprieved the Minister of Finance, and a statement came out following that. Is there anything else you wish to add to that?
Well, Cabinet has looked at the situation and found that the President has done the right thing by granting a reprieve to the Minister of Finance, Honorable Winston Jordan. We believe that the action itself was frivolous, was vexatious. It has no merit. You do not go after the person in a matter where a liability is against the state. You cannot enforce that decision by going after the minister in person. It's going to open our processes to abuse. It means that anyone can go against a judge You could ask for the imprisonment of a magistrate. You could ask for the imprisonment of the president, of the leader of the opposition. The law presumes that persons who do certain acts in their official functions, they are not liable in person. And therefore, to seek the imprisonment of a minister for a debt that had accrued or a decision that had been made against the state smacks of vendetta. And it's, for me, a kind of a judicial wrath for us to talk about imprisoning a government official, a minister of the government who was exercising his function officially, to penalize that person in person for liabilities they may not have been accrued to him personally. Cabinet not only supported the decision to grant the reprieve until all judicial processes have been completed, but Cabinet reposed confidence, full confidence, in the Minister of Finance, Winston Jordan. We believe that the action against him had exposed him to contempt and ridicule. We believe that it was unfair and unjust and unprecedented that this should happen to a public servant, someone executing public policies and public functions. And we believe that this attack on the integrity of the minister was unwarranted. It was unwelcome. And we want to say very openly that all members of the cabinet, all his ministerial colleagues, believe that he has done nothing wrong, and that he is completely exonerated from any shadow of or doubt that he was anything other than honorable. And he has received our full support, and we empathize with him and his family that they have been made to go through this degrading experience of being mocked by the opposition press, that he was going to do jail time, that he was a potential jailbird, and that he was going to do some horrible things in prison they had anticipated would happen. I believe that this crass political attempt to cast aspersions on the character of the finance minister should be totally rebuffed by the Guyanese people. And they should repudiate it with the same contempt that the attempt was made to besmirch the character of the minister. So we are going to stand together on this issue, and the Guyanese people, they know that we have persons of integrity in our government, and this cheap political ploy to bring them down and to try to cast odium on their character, it will not succeed. So I want to say this as much, that the decisions, the judgments that have been made, the orders of the court to give the huge amount of monies, billions of dollars, among to several contractors, most of them, three of whom are outside our jurisdiction in Trinidad, was done under the former government. And these deals have been made to take taxpayers' money and to settle litigation. Our government didn't do that. This is not the debt incurred by our government. It was incurred by the former government. And for them now to come out with glee and an expression of content that the minister was going to go to jail for the crime committed by them, if not a crime, by an omission, or an act of omission or commission done in their time, for me it is pathetic. And so the saying, Peter pay for Paul and Paul pay for all, cannot apply to our government. We cannot be held liable for the omission or commission by the former government. And they should take no gratification, the opposition, that this process is on the way against present government, because there's karma, they said, some people say it's a bitch. It's going to come back to haunt them for the things they did in their time. And they try to put the blame, cast the burden on another government. They're not going to be able to pass the buck infinitely and forever. Karma is going to come after them.
And this is the first time something of this nature occurred?
Oh yeah, this is unprecedented. I can't think of any time in the history of this country that the court has ordered that a minister, a sitting minister, should be held in contempt and should serve a prison term for a judgment that was made against the state. It wasn't against the minister personally. It's not the minister who owns the money. He might be the custodian of the public purse, but it's not his money. And therefore, all actions fall under the Liability Act on the state and not on the person of a minister. So it's unprecedented. It never happened before.
On the flip side, do you see something like this affecting his character when he has to come into business with international partners on behalf of the government?
The finance minister is the face of our country, together with the Minister of Foreign Affairs. When we go to the World Bank and the International Monetary Fund, the IDB, the Caribbean Development Bank, the Islamic Bank, whenever you go to international financial institutions to deal with the requirements of our country for assistance or for loans or for grants of some type, it is the Minister of Finance who would conduct the financial business of the state. And if you try to impugn the credibility of the Minister of Finance, you're not affecting the Minister of Finance personally only and his family. You're affecting the state. You're discrediting the state. You're trying to affect the capacity of the state to deal in a credible manner with international institutions that could help our people, that could bring relief to our people. And this was therefore seen for me as a sinister attempt at undermining the efficacy of the state to conduct business with foreign partners.
You just mentioned dealing with people. I think recently he did an interview where he indicated that there will be provisions, or he foresees provisions for increasing public servant salary again in the next budget.
Yes, sure. So therefore, the Minister of Finance is there as the Minister of Finance for all the people of the country. And he sits there over the public purse and look at the judicious way in which the money can be allocated between current expenditure and capital expenditure to be able to provide resources for infrastructural work, schools, medical institutions, etc., housing, drainage and irrigation, and also to see how much of it can be made available for emoluments to meet the pressing demands of the labor force, of the working people, for improvement in their salaries and allowances. So come back to what I said, the money that he presides over, the taxpayers' money, the consolidated fund, is not his personal fund. It is held there, held in trust for the people, the welfare of the people. So if you brought an action that you want to send a minister to jail for not paying somebody monies out of the consolidated fund, you are acting in what the law describes as in personam. It's not the person, it's the state that you have to act against, not the person. And so that is one example, fine example, where it shows that the money that he is ostensibly in possession of is not his, it belongs to the people.
Thanks, Prime Minister. Now, you've said recently, and now some people might want to term this as a hot button topic, but you've said recently at a community meeting, you've accused actually the opposition of being racist and selective in criticizing land allocation by the present government. Why have you come to this conclusion?
Empirical evidence and from reality and experience. I said that those who are now criticizing the land policy of this coalition government, they have to look at their own tenure in office. I have always said that there is something that we deal with as lawyers. It's equity. That's the principle of equity is that he who comes to equity must come with clean hands. You have to start on that premise. You have to come with clean hands. So here is a former government, now in the opposition, whose track record in dealing with state land and state asset is dirty. It's dirty as filth. And you want to cast aspersion on the land policy of this coalition government? No way. We know about the sleaze associated with Pradoville 1 and Pradoville 2. I remember being Minister of Information that I had to complain about the removal and destruction of the mosque belonging to GBC that was commissioned by Chedi Jagan by the foreshore of Leland Sparn Dam. And that thing was demolished just to be able to make way for the elite, the PPP cabal, to take prime state land by the seaside and arrogate it to themselves and parcel it as if you're dealing with chunks of fish by the seaside among themselves. They had done that before in Pradoville 1. Now they did it in Pradoville 2. Some of them used the government as a real estate agency. And so they were taking lands, building houses on them, mansions, virtual palaces, and they were selling them back. They were speculating as if they were real estate agents. And not only that, they were valuable state assets, state resources that were hived off to their friends and party cronies. They hived off the strategic airwaves, the spectrum, to give licenses to their friends, to their cronies, to their comrades, and even to the party. They had frequencies to open radio stations, television stations, and multiple frequencies in different areas in the country. Strategic resources. And they did so unconscionably. And today they saw a few lands going to a few African persons, persons with African names and African look and appearance. And they have come out and said government was hiving off the land in a corrupt manner. I believe that the PPP, the Jagdeo PPP, should hang its head in shame that they have helped themselves to state resources and gave to their friends, and they took this racist and selective approach of attacking those persons of African descent who have been given lands, for which they said they have applied during the Jagdeo and Ramatar period. Those applications were not made recently, but I know about what happened with their friends. Irrespective of whether they were Indian or African, their cronies were given large swaths of lands. You go up in the East Bank and see how much land was given away to some of those cronies. And you will identify lands given away in Kanji, lands given away on the East Coast, land given away on the East Bank, on the Susai Highway. You look and see how many of those came forward as if they were developing the land for housing. And they arrogated those lands to themselves and for their own profit. So I feel very personal about this issue because Guyana has 83,000 square miles, and there is enough land for everyone. They're entitled to communal titles of their land. And there's a law that protects the rights of our Amerindian or indigenous peoples to communal land. And the process of demarcation of the land has been, over many years, among different governments, it had been honored as part of our process of redistributive justice to our Amerindian people who were the original owners of this land and were driven out by the colonizers and driven away from lands that they have occupied before anybody else. It is justice for them that you have a government that seriously pursue land distribution to our Amerindian people. It is justice to the persons of Indian descent whose hereditary right to land that had been given to them by their forefathers who came from India to work in the sugar estate. They were given land in lieu of repatriation to go back to India. Those lands remain in their families as part of the hereditary rights. Lands in the sugar belt were given to Indo-Guyanese sugar workers. Places like Blackbush Pola was open in Essequibo. Lands, schemes were open for rice cultivation for which they were proved to be, to have had an aptitude. And they are very industrious, and they develop lands throughout this country that were formerly sugar plantation lands or lands in the sugar belt. And so no one envy anyone, any of our ethnicities for having lands. There are lands that have been bought by slaves, freed slaves in Victoria, Golden Grove, on the East Coast, other parts of the country. Slaves, freed slaves bought lands. Those lands had been considered to be ancestral lands. And therefore, they're entitled to the land where they had given their lives. They have been brought here as non-salaried workers to build the infrastructure for what we knew was a sugar industry. They build the infrastructure for the economy of Guyana. All the drains and all the canals and all the beds that have been made, the drainage and irrigation system, they were built with slave labor. And today there is a debate in the world whether they were entitled to reparation. And we saw that there is a just and demanding case for reparation to all for slavery, for the contributions that had been made. Walter Rodney wrote about how Europe underdeveloped Africa. The question is reverse: how Europe and Latin America and the Caribbean develop, how Africa, Latin America and the Caribbean and Asia develop Europe. It is the wealth of our countries that made the metropoles as rich as they are and as powerful as they have become. And therefore, we have to look that charity begins at home, that those whose ancestors have contributed to the development of our country, to the foundation of our country, that they are entitled as part of their patrimony to the resources of the state. And the state has many resources, and the resources must be distributed in a non-discriminatory way. You have resources not only in terms of land, you have resources in jobs, scholarships, contracts. These and others must be done in a non-discriminatory way, or else you will build social tensions among the ethnicities and among the peoples of our country. And so when our African brothers and sisters, I remember in the 70s in the movement that was led by UC Guyana on the East Coast, that had sparked what was called then the resistance struggle of the 70s. I joined that struggle on the East Coast for land to be given to African people. In a country where you have so much land, people have been homeless and landless, and they had nothing to do to resort to for productive livelihood. And so it is part and parcel agrarian reform and land distribution These have become part and parcel of the struggle for economic independence, to convert our political independence into economic independence. And anyone who comes out against land being given to any sections of the Guyanese people is going to meet stout resistance from people like me, and justifiably so from all Guyanese people. They cannot be selective in their attacks against those who have land. Not the PPP, not the Jagdeo PPP. That didn't happen under Jagan. And I can tell you this, that I can say this with confidence today, because in all my life as a person in public life, which I started in 1961, almost 60 years ago, I have not owned a single inch of state land. I have not applied for any state land. I may feel that I was entitled to it. I might feel that I have done something for my country that gives me an entitlement. But I have never, while I was in public office, I have never sought a single inch, not a lot, not a plot of land. I bought my own land with my own money from a private owner. And my wife and I, we pooled our resources, our meager resources, to build our own home long before I came into becoming a minister. And so I believe that what I'm saying here today should send a message for those who are picking quarrel and battles with those other persons who deserve land as a resource for which they could pursue sustainable livelihood, that they have to examine themselves. They have to examine their own involvement in the acquisition of state and government lands for personal use and personal appropriation. And so I don't want to say more on this, but this has stirred my soul to see the nastiness that comes out of people who have helped themselves to state resources, accusing others of getting giveaway lands. Come on, we have to be more civilized in our conduct, particularly when we hold office, and not try to make every issue a battle of contention and a grouse that you have to prosecute against people who only wish is to be given an opportunity to own something so that they can contribute to the development of our country.
PM, I saw how passionate you are about this, and I hope that we can get to do this conversation again. I want to talk about your column, I want to talk about your life, your history, how you got here.
But as you see, I'm passionate about some issues, and when I have an opportunity, I don't put a cap to my emotions. And I think that this makes me feel good, having said what I have said just now.
Well, thank you very much for your time. Today we had the Prime Minister of Guyana, the Honorable Moses Nagamootoo. This is your edition of One on One. My name is Ernestine Leonard. Thank you for joining us.